Okay, today we're going to talk about corporations. And so we'll start off by talking about how corporations are formed. Corporations are created by governments, that is, they are creatures of the state. They're not natural born, although they're given personal status or given the status of legal persons by a fiction that was created by the Supreme Court in 1887. Most are created under state incorporation statutes, so these statutes provide for the creation of a corporation. And it was at first a corporation would usually have to state some purpose that was to benefit the country or the state. But that's no longer a requirement. They can just simply be organized just simply to make a profit. Of course, if they're profit making, they need to make a profit then. So we do have benefit corporations, and that's another category we'll talk about as we get into it. But benefit corporations state a purpose for which they are organized and report, and they're required to report on what progress they made towards that benefit, whether it be an environmental benefit or a charitable benefit of some sort. There's some sort of public benefit, some sort of community benefit. Most are created under state incorporation statutes, but some are under the federal incorporation statutes. So we've had statutes like federal statutes like Fannie Mae, which used to help homeowners buy houses. It was very important legislation of the New Deal that was sank in the midst of the 2008 crises. Fannie Mae disappeared as it took on a lot of debt from poor householders who had been preyed upon by bankers, and so we talked about that before. In the Santa Clara decision of 1887, the Supreme Court, without citing any precedent, declared corporations to be legal persons, which is rather interesting. Yes, there was no legal precedent before that. They had not previously declared that. No state had done so either. And in fact, the English law, which oftentimes was common in the absence of American law, so we recognize English common law. The English law, Blackstone, was very clear that corporations were not persons, but they don't even mention that in that decision. But that, in fact, was presumed by many lawyers to be the law of the land. They just said, "Oh, we've always thought of them as being that." So, to some extent, it allowed them to then tax corporations, but it also gave corporations status as purpose to claim constitutional rights as persons, which they do. As such, to be constitutionally protected from unreasonable government intervention, they assert that. Nature of corporations. And corporations basically separate ownership from control. So you have the owners who buy the shares and vote for the directors, and each shareholder votes his number of shares. So your vote is maybe greater if you own a lot of shares, and not so great. So if you own, let's say, 5% in a large corporation, that will oftentimes be enough to give you control of the corporation if you own 5% of the shares, because there's so many people that won't vote their shares, and 5% is a huge block. Of course, you could, if you wanted to, if you had decided to incorporate a business that you had started, say you were Henry Ford, you had started this very successful automotive business and had an automobile that nobody had anything like it that could compete with it, an automobile that was good and sturdy and could be driven on the rough roads that they had at that time back in the early 1900s. You had this business making these corporations. It was your own private business, but you needed capital, you needed money to expand your business, and you didn't want to pay the interest rate. You could decide to actually incorporate your business. You would go to usually a banker, an investment banker, and he would basically underwrite your issuing of shares, meaning that he would either buy up the shares or he might guarantee their sale so that he would attempt to sell them for you, and if he didn't sell them, then he would buy them, or he might attempt to sell your shares but not guarantee that he would be able to get them all sold. So there's various ways in which he could underwrite it, and then he would issue those shares as an initial issuance of stock. So incorporation separates ownership from control. They are owned by one or more shareholders, so there's no specific numbers of shareholders, and shareholders could be any number. And some some corporations have very few shareholders, maybe only 3. So for instance, Ford, I think his initial corporation was he, himself, and his wife and his son, and basically he had control because he had most of the shares. Just in case they were wondering. They couldn't gang up on him. Between the two of them, they didn't have 50% of the shares. They had less than that. And he always maintained control of his corporation that way. He always owned the majority of shares, so he could always control it. And he ran the corporation the way he thought it was best. And he did a wonderful job for 20 or 30 years. But then General Motors came out with a car which was, that car had colors. So Ford was producing a lot of cars real quick, and the only paint he could get that dried fast enough for him was a black paint. So he started producing only black cars. And although at first there had been some green cars that he had made, mostly all the Fords, the early Fords, were mostly always black. And he refused to change that. And he also refused to do some of the decorative stuff that and some of the design stuff that General Motors was making. So General Motors would make fancier cars, but they were still cheap, and they were dependable. They were maybe not as dependable as Ford, according to some people, but they were dependable cars. And because you could get them in colors, and you could get special seats in them, and other special features would come out in these General Motors cars, they basically became Ford's competition. And later other car manufacturers joined in, Dodge and others, Buick, and competed with them. Oh yeah, there were at the time that Ford entered the market, there were some very nice, very expensive cars that were bought by the very, very rich, the Duesenberg cars. And these cars were created by a team of engineers, so they weren't produced on an assembly line. And they were basically very much tested and controlled by these engineers who would build it to exact specifications, and every one of them was a jewel and a very wonderful car, but they were outrageously expensive, and only the very, very rich could afford them. And so they weren't competition for Ford. So they're owned by one or more shareholders. They are controlled by directors and officers. So the directors are elected by the shareholders, who are the owners, and the directors basically then hire the officers, and the officers do most of the day-to-day business. So they will hire other employees. Mid-level managers and lower-level employees will all be hired under them by whatever management system they set up. And so the directors and the officers are going to be immediately responsible. The directors themselves, no director themselves will go in and tell anybody to do something in the corporation. You know, that's what they have the officers for. And it would be very confusing if these people had to answer to more than one thing. Although the directors were obviously in charge and could fire the officers, they wouldn't be firing, say, the lower level employees. They would leave that to the officers. And the directors could be removed only by the shareholders. And usually that would require a vote, because that's how they were put into office. That's how they got to be directors, okay? And of course, these directors and officers were considered agents of the corporation. And so, as such, there were certain responsibilities. They are separate legal entities. That is, they can sue and they can be sued. You know, so the corporation can sue other corporate businesses if it's infringing on its copyrights and patents. Ford had a number of patents which he and his team of engineers had created to create the car that would be able to drive on that road. So he had, I don't know, 50-some patents uh, outrageous number of patents, which he was largely responsible for. So he was a genius, no doubt. They pay taxes, and so we have double taxation. They pay taxes, and they also issue dividends to the shareholders. And of course, the shareholders will pay taxes on their shares. They'll pay taxes on their dividends. They pay for the increase in value of the shares, as you know, especially when they sell the shares. They, basically will have to sell for the increase in value, and may even pay before that under some provisions. Okay. Taxation. Owners are only taxed upon receipt of dividends on profits from the sale of shares. Upon piercing of the corporate veil, they may be made to pay. So we'll talk about piercing the corporate veil. That is basically saying that the corporation was a sham, or that the government is not willing to recognize it for some reason. So we'll talk about that a little more later. Or if they own shares in an S corporation, they'll have to pay income tax, because those shares will result in direct payment of the profits to the shareholders in the S corporation. So S corporations are a special form of corporation. Nowadays, of course, we also have limited liability companies and limited liability partnerships, which have oftentimes, well, limited liability partnerships almost always are professionals like lawyers and dentists and doctors will perform these LLPs, and they're pretty much like a partnership in some ways, but there would also be, with the S corporation, the LLC, and the LLP, there will also be limited liability, which is one of the big reasons, and we'll see part of the nature of corporations originally was to allow for limited liability. Okay, so the corporation is taxed. So we have double taxation, and unless of course you create an S corporation, you don't have double taxation. That's one of the reasons you create an S corporation. There are limits to that, though. You can only have 100 shareholders, so those are not going to be sold on exchanges typically. Constitutional rights of corporation. Most of the rights and privileges of citizens of the U.S., however, they're not granted the privileges and immunities of a natural citizen. For instance, the 14th Amendment, due process, liberty, and property, that's a right of a corporation. 4th Amendment, prohibition on unreasonable searches. So when I was going through law school, the OSHA had in its statute creating OSHA, the Occupational Safety and Health Act, there was a statement that OSHA could come in and do inspections at any time without notifying the managers of the plant or the owners either. So without notification, they could just show up and say, we're here to inspect to make sure you're complying with our regulations. Do you have your posters up? Do the workers have the necessary equipment that we require them to have? If they're welders, they've got to have the mask, and they've got to have the gloves, and for various jobs there would be maybe various kinds of equipment that would be necessary, depending upon what the company was producing and what it was storing and packaging and working with. There might be some sort of requirement that there be masks and that the packages be handled in a certain way and be safe and secure, and that workers would need to be notified by posters that these products contain poisonous gas. And if you feel something funny, you should get out of there and tell somebody, tell your managers and then leave, because this stuff can be very highly toxic. Anyway, the 5th Amendment, this applies to agents, but not the corporate entity. It is not granted the privileges and immunities of citizens. So agents can claim the 5th Amendment, so they don't have to testify against themselves. Other 5th Amendment rights they have, not so much so for the corporation. The corporation has to produce evidence. Torts and crime. Torts. Corporations are liable for their agents and other employees' actions. So employees and agents, like the officers, are considered to be like servants under the law of Rome. And under Roman law, a master was responsible for the actions of his servant. If his servant committed a tort, the master would have to pay for that. And so corporations If they have truck drivers, if truck drivers misbehave, drive recklessly, negligently, then they have to pay. If employees working for the corporation commit fraud on others, then the corporation winds up paying. The corporation will have a right to proceed against the employee to recover damages, and they can dock their wages. However, there's a question whether you want to keep an employee who drives negligent or who commits fraud. You probably don't want to keep that employee. So unless it's just a minor thing, you're probably going to get rid of the employee. Crimes. Modern statutes hold corporations liable for crimes of agents and employees, but obviously the only punishment that can be used against the corporation is a fine. You cannot lock the corporation up and put it in jail. You cannot electrocute it. So I've always thought it's a rather bizarre thing that we actually apply these crimes, although I understood that it was something that was done to corporations, early on, and I can understand why some people think this is a good thing, but I actually think that in some cases it's probably counterproductive. So for instance, with Enron, yes, Enron committed certain securities laws violations and was prosecuted and went out of business, meaning that we, instead of having 5 big accounting firms, we had 4 accounting firms, and there are all these employees, many of whom were innocent of any wrongdoing, who worked for Enron, suddenly had to find themselves another position, although Enron still continued to exist in overseas offices and overseas parts, but it went out of business here. So basically, the fact that you can send a corporation like that out of business by bringing a lawsuit alone, if you bring the lawsuit alone against a accounting firm, that will be enough to destroy its credibility and destroy the trust of potential customers. The customers don't want trouble, and so Enron was dead once they filed the lawsuit, the criminal lawsuit. But obviously, the only punishment they can be made to pay is fines. So and corporations sometimes make so much money that the fines may not be enough, and and they need to be proportional. If they're punitive damages, they need to be proportional under Supreme Court rulings. So, also in many places, if say it's a county that's not a very large county, and it's got a steel plant, and that steel plant is the employer of 3/4 of the people who work in the county. The other people who work there work in restaurants and stores that sell to the people who work in the steel plants. Okay, and the judge hears this case, and he's asked to, ask for a very big fine, and he does some calculations where the corporation tells him some of the facts of its financing and its economic and financial position, and he determines that if he indeed punishes them severely, like the people who are wanting to prosecute it want it to be punished, if he does that, he's going to put it out of business, meaning that everybody in the county is going to be unemployed. He's not going to do it. And so even if the jury comes back and gives a huge award, he will likely lower the award. And he can do that as a judge. He cannot increase, judges cannot increase the award of a jury, but they can reduce it if they think it's excessive. And so they'll probably do that. And typically they do that in those kinds of cases. So agents and employees, however, can be subject to criminal charges. So corporate sentencing guidelines of 1987 increased the penalty. So this was before actually the Enron scandals, okay? And it had already increased the penalties available to punish corporate agents and employees. After that, actually, Sarbanes-Oxley Act also increased penalties. And, I don't think the penalties were deterring these criminal defendants when the reputation of the SEC and the DOJ was that they weren't interested, or they weren't actually prosecuting, they weren't pursuing cases, except in very outrageous cases. Maybe they would pursue it. But there was a lot, one third of the big corporations on Wall Street being exchanged in the New York Stock Exchange, 1/3 of them had overstated their income for years. Enron and the 30 others that were largely indicted and subject to criminal prosecution and went bankrupt, those were maybe just the worst examples. Enron had been actually a company that had not made a profit in years, but it had reported profits and kept hitting its numbers according to its reports. But there were people who looked at Enron's reporting, its annual reports, and said they couldn't make it out, that they couldn't understand what was going on in it, and they would not trade in it. So these were some of the people who were more experienced in oil and gas, and therefore they wouldn't trade in it. And Enron said, oh, those are just old fogies, they don't understand what's going on. When Bethany McLean, the reporter for Fortune magazine, before she wrote her famous article on Enron, she was talking to Jeff Skilling, and he told her, you don't know what you're talking about. And of course, she did know what she was talking about. She was a very smart quant. She had been a quant and had worked at investment firms calculating, doing quantitative analysis on issuing these derivatives that were later to get the whole country in trouble in 2008. So she was very, very good, had been to Princeton, graduate of Princeton, which was the place for people who would go into the security industries at that time, were mostly Princeton graduates, and she knew what she was talking about. Skilling apparently didn't know what he was talking about. He'd lost money when he was a teenager investing in stocks because he was very aggressive and took too risky a position. And he and Ken Lay apparently, well, they said they didn't realize anything was wrong, that they had relied upon the accountants, and obviously they should not have been so naive. Even, Ken Lay saying he relied upon his accountant even after having received from his vice president that famous letter that brought it to the attention of the public when it got circulated among the secretaries in Enron, and so that was Sharon Watson, right? Watson. She was a whistleblower, right? And she was an accidental whistleblower. She didn't intend that to go to the public. She had given a letter to a secretary of a friend of hers who was also a leading officer in the firm. He was the man in charge of some accounting aspects, and asked him to read it and give her advice on it. And that secretary had read it herself, and she got the idea that she understood it, that it meant that Enron was in danger of imploding, and she circulated that information amongst all the secretaries, and eventually it got to Wall Street Journal, and it was published. And so she got credit. Sharon Watkins got credit for being a whistleblower and celebrated, and was not prosecuted even though she had engaged in insider trading, and that she sold the stock of Enron, knowing what she did. But they thought they had enough people to sue it. I think they sued. There was like criminal prosecutions. There was maybe 80 people at Enron that were prosecuted, and she was a person who had tried to oppose what those others were doing to the firm and wanted to shut it down, and just wasn't being listened to. Okay, so so prosecutors oftentimes have some discretion, and it would have been really strange to shut it down when she was actually credited for bringing it to the attention of the public, although it was accidental actually. 5 to 10-fold increase in penalties available to punish corporate agents and employees. Okay, and that was increased, and it's not just the fines that were increased by Sarbanes-Oxley. It was a time in prison. Although I note that what Ken Lay was sentenced to 20 years, and Skilling was sentenced to 24 years, and some other person, another agent, another officer at another firm who had engaged in similar sort of misdoings and cookies of the books at a competing oil and gas company was given 25 years. And you look at it, these people were given huge sentences, and these were people who were older, and many of them some of them would almost predictably die in prison, although I imagine that by now Jeff Skilling is out. I think Ken Lay has died. I don't know whether he was in prison at the time, though. Oh yeah, he died. No, he never went to prison. He died when he went to the Rocky Mountains. He had heart disease, and he didn't take his medicine, and he died. Some people thought he committed suicide that way, which would be a bizarre thing. But yeah, he died before he could appeal his case. So his case never went through, and his widow got to keep the money, which he would have lost. They would have lost had he lived. Anyway, you think she was involved? No, I don't think that was it. Anyway, no indication that there was anything that she did wrong. Okay. Depending on the seriousness of the crime, the amount of money and extent of the involvement of high-level corporate executives, fines of hundreds of millions may be imposed. And nowadays, these executives may be sent away for years and years and years. Now, this would not be done by the SEC. This would all be done by the DOJ, Department of Justice. They have responsibility for bringing criminal cases. The SEC can only bring, because it's an administrative agency, right? Administrative agencies can only bring civil cases. They can only, go after fines. They can, make you pay a fine. So, courts mitigate if corporation has reformed itself. The prosecutors at that time would, and I am sure they did, threaten the board of directors that they would bring a case against Enron itself, which would of course wiped out the corporation, which got wiped out anyway, because its share price fell to like 14 cents and it had been trading up at 125, and it had greatly lost value, and some people had lost a huge amount of money. And for some of them, it wasn't just simply all paper profits. For some of them, it was their pension money. So a lot of the people at Enron were trading in Enron stock, buying Enron stock, and they were putting all their investment monies and all their pension monies into Enron. And you don't ever want to do that, because that's putting all your eggs in one basket. And they simply were in bad shape when Enron went down. And even if you had sold when you heard about the Sharon's memo to Ken Lay, the stock was dropping very quickly. At that point, once it got in the hands of the public, people were selling it. DOJ, Department of Justice, will establish a culpability score. So the Department of Justice, they have the prosecutors, they have the attorneys that do the prosecuting. They will look at the firm and see if it is been cooperating with them. And so this gives an incentive for a firm to cooperate. Otherwise, the firms may be resistant to it. So firms have sometimes paid for the defense of their officers, and this is not seen as cooperating. Culpability score. It's a formula measuring the role of senior management companies for history in the company's history of violations, extent of the management's cooperation with investigators, and effectiveness of its compliance program. So a firm will get credit for, one, establishing and communicating crime prevention standards and procedures. So they need to tell their workers how they should be, that they shouldn't be committing crimes, and they should be reporting crimes. And also the second thing is they will get credit for enforcement of those procedures. So it's one thing to issue these standards and these procedures, and it's another thing to actually enforce them. A third thing is elimination of discretion to problem employees. So it should, notice when an employee is creating a problem or doing something that's kind of suspicious, and remove his authority. His discretion would be cut back. So obviously, Andy Fastow should have been removed long before he was actually removed. It had to come out in the Wall Street Journal before they removed Andy Fastow. Before that, he was the genius who was, the greatest financial officer in the land. So he won the Chief Financial Officer Award from CFO magazine, of all things. And but his genius was not so much genius as it was a willingness to cook the books, very crudely, but I might add. 4, establishing methods of detecting crime. 5, protecting against reprisal for whistleblowers. They have to set up some reprisals of their own for whistleblowers, or protection from reprisal for whistleblowers. That would be something. So that's not typically done. As a matter of fact, a whistleblower will generally suffer from the eyes of other employees. Now, I don't think Sharon Watkins did, but in some cases where a person's reporting on something like dumping of toxic waste, the other employees may want their jobs even though they know the corporation is doing these evil things. They may be so dependent upon their jobs and feel they can't really get by without it, that they will resent somebody who turns in the corporation, because it means they'll lose their job. They'll have to find another one, and they're maybe older and can no longer easily find a job. Corporations. Prior to incorporation statutes, promoters of a corporation were required to state some public purpose to persuade legislatures. So before corporation statutes were made, you had to go to the state legislature and get the state legislature to enact a bill. And so it was very few corporations were created. And usually the corporations that were created had some public purpose, like the Erie Canal. It was to improve the transportation system in New York. So the New York legislature created that Erie Canal, which was a boon for the state of New York. And it was set up as a private corporation and was expected to generate its own funds to and not be a burden upon the taxpayers. So, you know, the states can still do that, and still do. The post office, it's a federal corporation, right? It's run privately. However, we've seen recently that the president can have a lot of influence on that private corporation. So, private corporation statutes are required to state a public purpose. They're no longer required to do that. They can just simply state that they're going to make money for the public, for its investors. That's the corporate powers flowed from the stated purpose. Today, corporations state other purposes, including the attainment of profits. You know, maybe that's the only thing that they say they're there for. The corporation is therefore constrained to some extent by such purposes. So if they do have a purpose statement, if they say that they're going to engage in the airline business, then they need to engage in the airline business. So they have to follow their articles of incorporation and their charter. They have to follow that. So if that's what they said they were creating a corporation to do, they have to follow it, even though it's under a statute now rather than a legislature. Corporate powers. Corporate powers flow from a number of different sources. Some are expressly found in the articles of incorporation, in the bylaws. They also may be expressly found in the Constitution of the states, and also the laws, the legislative laws of the state of incorporation. So the Constitution of the state and the state of incorporation. So there was a period of time in which we had the race to the bottom, where various states competed to see who could attract the most corporations and collect fees from them. Delaware won. And still to this day, there's a lot of people who incorporate in Delaware. Next to Delaware, then New York, I don't know, it was so much that it was won the race to the bottom. It didn't win the race to the bottom. Delaware won that. But it was a favorite state of incorporation. I think it was largely because of a lot of businesses. And then Wall Street was located there, so it was something that kind of produced that. And they did enact several corporation statutes, and even to this day are almost a rival to the Securities and Exchange Commission and the DOJ in terms of enforcing securities laws and regulations. So they have their own laws and their own regulations in New York. Okay, there are also some of the corporate powers are implied. All acts reasonable and necessary to accomplish its purpose would be things that are implied. Ultra vires actions, if you hear about them exercising a power, are considered beyond its power. So ultra vires actions is something that's not provided for by the law from any of these other sources. So it would be acting beyond the law, beyond what they legally can do. Like I said, there's creatures of the state and therefore will be limited and constrained by only what powers the states give them. Ultra vires remedies. Shareholders sued to enjoin a corporation or seeking damages on behalf of the corporation. The corporate suit to require also the corporation may bring a suit to require an officer or director for exceeding his authority, to require him to answer for his excess, maybe getting him out of office. And nowadays it's not so easy, because a lot of times when they hire big name people to run corporations, they're given some sort of a package that if they're fired they will get so much. And so some people are actually getting lots of money after maybe even being forced out of office because it became part of the package under which they were acquired by that firm. So some of these are rather famous people. I think that happened at Disney, didn't it? Classification of corporations: domestic and alien, and foreign. Domestic, you're a domestic corporation only in the state in which you were incorporated. So if you were incorporated in Delaware, you are a domestic corporation of Delaware. If you were incorporated in Indiana, and there are Indiana corporations. You're an Indiana corporation. That's your domicile. Okay. Foreign corporation is a corporation that was created in some other state. So if you're operating in Indiana, but you were incorporated in Kentucky, you're a foreign corporation when you're operating in Indiana. What are you if you're Canada and operating in Indiana? Well, you're an alien corporation. So countries outside of the United States, if they have a corporation operating here, would be classified as alien corporations. Not that they have little green men showing up in flying saucers, but they're alien corporations. And now, whether it's an alien corporation or a foreign corporation, most often there is a law that requires you to notify the Secretary of State of Indiana that you are operating there, that you're engaging in activities there, and so they can collect whatever fees and taxes they apply to the Indiana thing. So they can't enact special laws. There's no, I mean, within the United States, there's no tariffs. We got rid of that when we formed the national government, the federal constitution that we have currently. Got rid of that. Under the Articles of Confederation, which we had before that, that was happening. That's one of the reasons that we had the Constitution of 1887 passed in 1889, was to get rid of these interferences in interstate commerce. And we have the Interstate Commerce Clause that says the federal government has control of that. That's being restricted, actually, probably unreasonably. And I think it's the only thing that keeps us together as a nation. And there were some early decisions that are very important. And now it's being restricted, I think, oftentimes to because of discriminatory reasons against blacks, actually. And so there are people who are bringing these up. And you see it in regard to the other day when I was listening to the arguments for the Supreme Court on the Affordable Care Act. And what were they arguing about? They were arguing whether or not, part of what their argument was whether or not, and this is once again being argued because it was already settled before, whether or not the Affordable Care Act was legally passed by the United States. Did the Congress of the United States have the power to write this legislation? And originally it was believed that the Interstate Commerce Act would support that. But nowadays, that's why Chief Justice is finding that there was a tax provision in it was important, because that provided a substitute for what was otherwise provided and thought to be provided by the Interstate Commerce Clause, which had for many years been seen as giving Congress the power to regulate things that were going to affect the whole nation and made us a national force. And why was that? Well, because George Washington and his men, which included Alexander Hamilton and and John Marshall, Chief Justice of the United States, all of them knew the importance of having a national federal government and not being dependent upon states that had not funded the Revolutionary Army. And all those men had starved to some extent during the Revolutionary War at Valley Forge, a disgrace, and they realized the importance of having a strong federal nation to stand up to foreign countries. So anyway, so other kinds of things, public and private. Public corporations are things like the Erie Canal. It's made for a public purpose, and it's started by legislation. Usually, the legislature creates this corporation. So these are not going to be incorporated under the statutes of incorporation. They're going to be started by the legislature. And there are other ones like the post office. Some schools were started originally by Dartmouth College, was started as a corporation. Cities are incorporated. That's why you have the corporation line going into cities. They're incorporated bodies. And, so these are public corporations, which are different than private corporations. Private corporations are those that are privately funded and privately held. And usually these are going to be for profit, but they may be non-profit. So we have profit and non-profit corporations, and of course you know the difference. The profit corporation has an obligation to produce profits for its shareholders. It pledges to do that, and it's required to produce some profits, some reasonable profits. Can it do things like give monies to charities? Yes, they've done that traditionally, and they'll, I think, be continued to allow to do this for goodwill to the public and to make them a good public citizen in the community, right? And so I've heard some economists rail against that these corporations should be doing these public things. But, I think it's a good thing that they do some of this. If they're persons, and we're not going to put them in the army and have them march through the mud, we don't do that with corporations, do we? If they're persons, I know, we sometimes pay corporations to go over there and do things, sometimes very excessively so, and oftentimes this was something that was not bid upon, which it should have been, but they're not in the same category. So if they're not going to do that for us, at least we could at least take some of their money. And so that seems fair to me. Profit corporations, non-profit corporations, have certain provisions protecting them. We'll also talk about benefit corporations. Benefit corporations are corporations that are there to benefit some public purpose. It might be the environment. So maybe it's a corporation trying to develop sustainable energy, like wind farms, or it might be a corporation that's providing health services for a rural community which is not served otherwise. I think the rural electric dams were actually corporations created by the public to do that. So, so nonprofit corporations. Benefit corporations can be therefore organized, and they're usually going to make a profit, but they also will be reporting on whether or not they, what kind of benefit they've been kind of getting. So these sort of like a report card for them. You said you were going to provide us with this, sustainable energy, non-polluting, and what kind of progress have you made on that? So you just got kind of report on what you've done. So that should have been obvious that you were going to do these things from your filing. Publicly traded corporations are usually traded on the stock exchange, although some of them might be traded over the counter, but they're publicly traded somehow. So, and then there are closed corporations, which are privately held corporations, usually with just a few shareholders. Then there are C corporation and S corporation. We talked about S corporation. These have special provisions. In this case, they people who own the S corporation, they don't have double taxation. They just have to pay the profits pass through them, much like an LLC or LLP, which we talked about. Professional corporation would be dentists and doctors and lawyers who get together, and they also would be pretty similar to the S corporation in that the money would pass through. However, there are some advantages, but for these professional corporations that are incorporated, generally they are still responsible for malpractice. So, if you are a lawyer and you commit malpractice, you become liable for it, even though you're working under the auspices of a corporation. You're not going to have that limited liability, even though you're an owner in that firm. Okay, and so those are the types of corporations. Corporate creation. The preliminary activity, the promoters obtain an underwriter usually. Usually that's how it goes. There are other sources of funding. We'll talk about that. And then they create a prospectus. So to sell the shares, there has to be a prospectus. A prospectus is basically information about the firm, what it's going to do, what products it's going to make, and what advantages it has. So it's basically a selling instrument that you have to give to, under the securities laws, that you have to give to potential subscribers. So at this point, the shares are going to be not owned. Nobody will own a share, but people will own a subscription, giving them the right to claim shares. So they put the money in, and they get the shares after the corporation is formed, and they have a right to the shares because they put the money up. So the underwriter, the bank that underwrites the investment bank that underwrites these activity will issue these subscriptions. And these are just contracts that they enter into. Required procedures. The promoters file and obtain a charge. Who do they file with? They usually file with the Secretary of State or whatever other officers there is. Like I think in Wisconsin, it's a different office, but it's the state office. And so whatever office is designated by the statute, the incorporation statute, you have to file with there. And it also, there would be the bylaws, which were adopted after the first meeting of the shareholders, and the directors are elected. So the directors and the promoters will oftentimes be the same one and the same, and actually the promoters, after the corporation is formed, will become called incorporators. Okay, so the same people, but they just name just changes because of the fact of it being incorporated. Documentation is important. If you don't document it properly, you don't follow the procedures, it might be that your veil will be pierced that will disregard the corporate entity and hold people liable as if there was no corporation. And they'll also do that for other reasons, like alter ego reasons. Filing. They file the documents of articles of incorporation and bylaws. They file the name and address for service of process, and they basically give the name and address of their headquarters. You can have your office in Delaware, but all your activity is going on in Indiana. That's a possibility. So maybe you're really an Indiana corporation, but your headquarters is in Delaware. But you have to designate a place in Delaware as your corporation. That's one of the benefits of the race to the bottom, right? That people have to create a headquarters there. It can be very slim, maybe just one man and a secretary and a file cabinet and some phones. And that'd be it, maybe. And that man really has very little power, if any. Funding, arranged by promoters, incorporators. The sources will be investment banks that underwrite shares, usually sold by subscriptions, and later will be issuing IPOs for the same firm when they want to issue any new issue of shares. Often nowadays, however, funding comes from crowdfunding. So it's being used for startups, and entrepreneurs are using that. Also, venture capital and other private equity may be used. Challenging the existence of corporations. De jure corporations, all corporate formal and statutory requirements are met. De facto corporations, statute allows for the incorporation. There was a good faith attempt and the business undertaken in corporate name, corporation by estoppel to protect third parties. They may recognize the corporation, but for other purposes it will not be recognized. So there's no limited liability for a corporation that's recognized by estoppel. It's just to protect third parties who are not part of the corporation, not the investors, not the officers, not the directors, not the promoters. It doesn't protect them. Disregarding of the corporate entity, of course, also, that's what we talked about. So the next slide would maybe deal a little more with that, but we're not going to be able to do that tonight, so maybe we'll pick up with that next time. Okay, thank you very much for that, and I'm sorry that this got to be quite long. I didn't realize that we would go on quite so long as we did. Matter of fact, I was worried about it. So, thank you.